Hello everyone, let's learn a little bit about equality and discrimination. As mentioned in previous classes, human rights are rights which are inherent to all human beings and rights related to human dignity. Human rights can also be called fundamental rights. The right to equal treatment and non-discrimination are human rights. The aim of non-discrimination law is to allow individuals an equal and fair prospect to access opportunities available in a society. This is how law intervenes in order to achieve it. First, those individuals who are in similar situations should receive similar treatment and not be treated less favorable unless objective and reasonable reasons. Principle of equity. Situations that are equal must be treated equally by the law, by the government, or by a public body. Principle of non-discrimination. Both public and private employers must not treat their employees differently because some protected ground. Secondly, equality of opportunity, which imposes public authorities the duty of promoting equality and removing the obstacles preventing or hindering their full enjoyment. Principle of equality tolerates different treatment only if they result from objective and reasonable grounds, only applicable to vertical relationships. It imposes obligations only for public bodies. Equality in the law or equal treatment. The legislative or the government cannot create norms which treat differently to situations that are equal. Equality before the law. The law must be applied equally for situations which are equal. Generally, differences in treatment are allowed in horizontal relationships. Employee-employer is an horizontal relationship. The law prohibits that companies make decisions based on several traits. Differences in treatment based on the prohibited ground are not allowed.
Direct discrimination, where one person is treated less favorably than another in the same position on grounds of sex or ethnic reasons. There's the anti-discrimination test to check if we are in front of an unfavorable situation. Then we have the indirect discrimination, where an apparently natural provision, criterion, or practice would put persons of one sex or ethnic origin at a particular disadvantage compared with persons of the other sex. There is a possible defense against ID. Provision, criterion, or practice may be objectively justified by a legitimate aim, as long as the means of achievement that aim are appropriate and necessary. Now we're going to talk about harassment, which is the unwanted conduct related to the sex of the person, with the purpose or effect of violating the dignity of a person and of creating an intimidating, hostile, degrading, humiliating, or offending environment. Scope. In the field of employment, anti-discrimination legislation protects employees or job applicants in relation to access to employment, promotion, access to vocational training or retraining, employment and working conditions, occupational permission schemes, and termination of employment. Their legal effects are nullity, access to procedures, and remedies. Then we are going to talk about two different proof of discriminations. The first of them is shift or burden of proof, and the second is statistical evidence. Thanks for listening to our presentation.